When do you want?
Well, June, month of June, any date other than 4th, after 5th, any date, convenient to your lordship.
You tell us when fix it on that day. So
Milord.
You suggest a date. You can.
Yes.
Satisfactory.
Milord, it can be on, Milord, 8th of June is a Monday. Yes. No procedure laid down for him. There is no specific court can know the procedure. He has to. I mean, yes.
Have you got tools?
Yes, ma'am.
Please come to page 283.
283. 283, madam. 283. It is start from 280.
283 is the relevant, right?
Yes, madam.
283.83, rule 8.3.
8.3 does not plead or claims to be tried by High Court does not continue. It may determine the matter. I don't affidavit after taking such further evidence. Yes.
So you'll have to take a plea. In fact, prayer for adjournment by Mr. Chaudhary was unnecessary. You'll have to take a prayer for adjournment and then file evidence. Either produce the witnesses or file an affidavit, whatever you choose.
My lord. My lord, to be honest, I am also not very well versed with this branch.
No,
I also would like to know, my lord, pros and cons of this.
Because Mr. Chaudhary, the thing is like this.
Yes.
For framing the charge, we
Yes.
have to have prima facie evidence.
Yes.
So without the evidence,
Correct.
if it is otherwise agreed that it will be on the basis of affidavit, it's a different thing. But there has to be some evidence which is normally there in a criminal contempt.
That's why, my lord, I thought I must make myself aware of all the pros and cons. That's why, my lord, basically that's the reason, my lord, I prayed for this. Otherwise, my lord, I'll be, because it's my duty to assist your lordship.
No,
Affidavit by my lord, your lordship can see. I have an experience, not as an advocate, but I have one matter before this honorable court that my matter, TJ Mohanta has came Madok. Justice Gyani has, my lord, taken evidence. Of course, in that case, contemptor was, my lord, he was in dock.
we are aware of that.
So,
That was one of the best things we saw in court.
my lord. So here,
The man was here almost daily.
my lord.
For about 3 months, he was attending the court daily.
And conviction was also that, my lord, till rising of the court and 1,000 rupees fine. But he went to the Supreme Court also now.
Because here the issue is a bit different, taking into account that he has already been convicted.
Exactly, my lord.
We have to
Here in this case, he is in probation, he is in, my lord, he is in probation because he has earlier conviction of 6 months, that was under suspension.
That's why you have to read evidence. You have to also bring on record the earlier conviction and all everything.
And in fact, my lord, the affidavit which has been filed by this, by Mr. Swami, my lord, not a single line written about that, my lord.
That's okay, but you have to do your part.
My lord.
But Mr. T.J. Mohtar was it. He was standing up for this book, assisted by Ms. P. Sharma Radel. Also had Mr. K. Jyoti Dhanet, senior counsel assisted by Mr. Ali Walker. Counsel for next on the paper made by the senior counsel for both sides. Matter stands adjourned today. Just to enable the
Last of
the court to do the needful in terms of rule 8 within bracket C of the contempt of court within bracket GSC bracket rules, 1977.
My lord.
This term,
My lord. वो देगा ना my lord.
Mr. Chaudhary.
Yes, sir.
We'll improvise in this matter. The evidence would be allowed to be led by affidavit, and we will permit you to cross-examine.
Yes. My lord.
Correct? Or you would like to have it in chief?
My lord.
Or you will,
Affidavit
instead of
is allowed
affidavit, you would
given
like
in
to have the evidence in chief? What do you want to do?
My lord, actually, I have to take instruction from my lord because it is not by the, it is by one judicial officer, my lord. So I have to take consolidate.
I think the better option would be for her,
To-
for the officer to first file it by evidence on affidavit.
Affidavit, that will be
And
better.
thereupon the cross if it is.
My lord, if required. Because
You may
what is here?
also have to take into account that these are electronic evidence.
My
So
lord.
therefore, all these certificates also would be required, because taking into account these are Facebook posts,
Section
who has downloaded, and what are all these things have to be taken. We'll have to apply section 61 and 63 of the BSA.
My lord. So let it be the last part of this rule, my lord.
But applications are coming.
My lord. Mazot lua, second is lua. 18 now 19. 18 now 19.
And you also have to think over so how to give evidence for that conviction.
My lord.
You'll have to plan it out.
18 or 19.
Okay, 18.
Leave them. Leave them. And he'll be present next day.
Yes, yes, but this we have not discussed.
But
I'm curious for just
specific
As- the procedure has agreed to by both sides would be that the evidence shall be led by evidence by the witnesses shall be by way of filing of the evidence on affidavit for the purpose of recording for the purpose of examination in chief, and the respondent side would cross-examine, would have a right to cross-examine those witnesses. And thereafter, the matter will be heard for framing of charge. And thereafter, After signature, any other evidence by this court or and rebuttal evidence by the respondent. If any, huh? Next meeting. So let me set the evidence in chief by this court. Examination chief, evidence, examination chief by way of evidence on impeachment by this court. By the witnesses of this court. So that we are laying down the proceeding.
First item of order, madam.
With regard to item number 10, here, so lot of, it is based on some problem here. I circulated the adjournment receipt yesterday.
This is 2016 matter. You can't give a long adjournment.
Yes, yes. On 28th, your lordship, the stop. In coming, 28th, 28th of May. I'm not
Both sides are represented. On the prayer made by Mr. Datta and counsel for respondent numbers 1 to 6. The matter stands adjourned today. As this is an old pending matter, we list the matter on 28/5/2026. No adjournment shall be granted on the said date.
May please lordships, I would like to mention item 3, my lord. I am for the appellant in this case, my lord. I have already obtained the consent of my learned counsel for the respondent, my lord. So, my lord, I would like to adjourn the matter, my lord.
But this is for hearing under order.
Yes, my lord,
41 to 11.
my lord, my lord,
2021.
Ahmed, he is not well, my lord, today, my lord. That's why, not short, any date, my lord, or after 1 week or 2 weeks, my lord.
Next week. 18th of May.
Next week.
Next week is 18th May. This week ends on 15th.
Sorry, 9.
No, 19th is hearing day. We have some old matters. We get 20 then. Also, they represented on the prayer made by learned counsel for the apparent matters which are drawn to the list on 20/5/2028. As this is an old pending matter of 2021. No adjournment shall be considered on the next date of this day.
Obliged.
In future, Lordship, I'd like to mention item number 25 and 26, the supplementary list. As my senior counsel is not well,
25/26 are 2016 matter. Let this matter reach first.
Lordship, we have consent from the other side.
25 is 2016 matter. We are now 10 years down the line. Sorry, let the matter be listed. They'll be called. We'll consider them.
Lordship, he is not present.
We don't know about that. 10 years old matter. We are not allowing adjournment just like that. Even if there is inconvenience, we can't help you. Let the matter be called.
May it please your lordship, with the consent from the other side, I beg to mention item number 14, lordship. Senior counsel Mr. G.N. Sahewala is out of station because of his elder brother Shraddh.
Both sides are presented on the prayer made by learned counsel for the appellant. The matter is adjourned today. List on. You did after a week. Okay. 25/5.
Lordship, similar prayer for item number 20, lordship.
Okay.
Obliged.
My lord, item number 1 and 2, that may kindly be taken as a floor clock.
1 and 2. Okay.
Floor clock. দুটা কথা আপনি যেটা বিচাৰিছিলে
public side.
For admission, for delivery of order, item 21, CRP 58/2026.
In this case, we have basically formulated your submissions in the following manner. Number one, that respondent numbers 21 and 22, where 21 and 22 or 20 and 21, the advocate and the lawyer.
21 and 22. 21 and 22.
21 and 22, okay. 21 and 22 are not members and therefore they are not parties to the arbitral agreement. Second point, we formulated that the cause of action could not be split. Thirdly, it affects, as the issue affects the civil rights of members and the governance of society. They are tribal exclusive by the civil court. And that the appointment of members, appointment of arbitration from among the members is contrary to the principles of justice. That is the points we have formulated on your submissions. We have held that the professionals who are the lawyers and the chartered accountants, they cannot be said to have acted independent of the respondent one society, and they were appointed, were working as being appointed by the office bearers of the society. So therefore, even in their absence, it would be permissible for the court as well as arbitral tribunal to set aside their appointment and restrain the respondent one society from acting in accordance with the steps so taken by them. Secondly, we have held that if they were illegally appointed without due process of law, then also the courts and arbitral tribunal will have definite jurisdiction and competence to pass such orders as may be permissible in law to restrain the respondent one society from accepting such reports and or decisions of the steps taken by those professionals or election officers engaged by the society. Therefore, the opinion is not found vitiated. Secondly, in your petition, you have made a mention that there is allegations of professional misconduct against the lawyer and the chartered accountant. If that be the case, then we have held that the civil suit may also hopelessly be barred and may not be maintainable against respondent numbers 21 and 22, who are professionals, and all issues arising out of their professional conduct and or misconduct are covered by separate acts and rules under which they are practicing. However, this is only a tentative view and not a finding of this court on facts. Thirdly, with regard to the dispute not being arbitrable, we have held that every decision of a society is by the office bearers of the board or executive committee, by whatever name called. Therefore, it can't be said that the issue can't be arbitrated. Secondly, we have held that since there was no fundamental rights of the petitioner and the suit was filed in personal name, you are not agitating, you have not filed the case in a representative capacity. So by whatever way you treat, the issue is not question of action in rem, but it has to be an action in personam, and therefore the submissions was not found acceptable, and therefore this revision fails and the same is dismissed. It will be released in the second half. There's some corrections. Last moment corrections have come.
Obliged.
Obliged.
For admission, item 1 with item 2.
No, second half. Second half. Mention kar lo.
Supplementary item 22.
Your Lordship, permits, my lord. Yesterday, earlier point, my lord, page 47, my lord, may I point out one thing, my lord. The suit they filed by the decree holder, my lord. They have admitted page 47.
Yes.
The suit filed by the, my lord, decree holder, my lord, subsequently arraying us as the defendant, my lord. There they have admitted, and there is a circle officer report, my lord. So may I read that page 47, my lord? Page 2, my lord. Page 47. The brief case of the plaintiff is that they are the absolute owner of plot of land of 3 kathas covered by DAG number 436 under PP number 158 that belongs to the decree holder. Situated Marwari Patti so and so, and another 2 katha 3 lessa covered by DAG
See,
number.
fundamentally, this is incorrect and absolutely wrong and disbelievable. Are you aware what a EMD road is?
Yes, embankment and this drainage.
So EMD road is always a road in the side of a canal or a waterway or a irrigation, what you call irrigation channel,
Yeah, ma'am.
correct?
Yes.
Please come, if you are reading this page 47,
Yes,
please come to the third paragraph.
third paragraph, ma'am. Yes, ma'am.
Line number 3, the defendant denied suit land situated in the southeastern intersection of the drain and defendants own 2 plots of land of 3 lessa and 3 lessa each on the side of the END drain. So one side I can understand there will be land, but other side will be drain.
Other side.
How can you have land on the drain of an EMD embankment? So absolutely false stand.
That is the recording of the judgment, my lord.
But if you are, you see, you are referring it. I did not point it out, but since you are referring, I am just telling you in this, the description of land given will not be believable. One side has to be the canal or the
Or
drain.
is that western side that there is between the suit land or western side?
If you read this order, you will not find anywhere
Right.
what you are trying to say.
No,
Either side of canal would either be the drain and the road. Either side of the canal cannot mean that this side and this side.
then your lordship, page 48, the last portion of the circle officer, discussion on circle
Page?
officer, report, page 48, my lord, of the judgment, issue number 3 and 4, that circle of may I read, my lord, that?
Yes.
In this case, parties have led oral evidence, but regarding the identity of the suit land, Dark Patta, the circle official spot verification is most vital to decide in this case. Plaintiff claimed that suit lane of him falls in dark number 436, where defendant denies the same. In spot verification report, the circle officer, next page, submitted that suit land with thatched house falls in dark number 441 of PP 159. That is our land, my lord, 159. And 44 of dark number 207, not under dark number 436 of PP 158. So PP 158 is their land, to which DW affirm in pros as DW1 deposed in pros that the disputed land dark number in 441 PP number 159. The DW affirm in evidence that land of the defendants bounded by North Kalibari Road, south land of plaintiff, and west there is a END dale. That is the thing, my lord. In the west there is a dale. Now
Only one side.
only one side, my lord.
We can't be two sides.
Yes, my lord. That I have to
Now,
now.
where is the judgment challenge in this order? Where is that judgment
That order, my lord.
of order?
Yes.
Yes, where is
Case 117, 117.
that? 17.
Yes, ma'am. Last annex, sir.
Where is the initial application
Yes,
based on which,
this is also discussed, my lord, page
so
117.
where is that document?
That document is annexed, my lord, page 33, my lord. Annexure 2. That application was disposed of by this order. Page 34 is the schedule, my
Just a moment.
lord.
And why did you give me a list of
Yes,
the
I
list we
prepared.
have asked? Because it's very difficult to look at this
My lord,
record.
I prepared now. Detail list with synopsis.
This page 33 petition is disposed of by order
Order dated 2/5/22, my lord.
522.
My lord.
which page is the High Court order?
High Court
Is it
order,
Page 59.
yes, Lordship. That is,
Page 59, High Court order.
59.
Please keep in mind that since I am reading cursorily and not word by word, I may miss out certain facts. So if I am wrong on facts, please tell me.
My lord.
This judgment of Attitude number 8 of 2008 was passed on 30/11/2012,
20,
right?
my lord.
In this judgment, you say that there is a line favorable to you because there is a reference to that number 441, right?
My lord.
Come to page 59. 59 is the High Court order
Yes,
of 13/5/15. On that day, you had an order with you having one line favorable to you. Correct?
my lord.
Before this court, when this court was passing an order to send for Amin Commission, you did not raise that point of 441. It's not there in this order. Please tell me if I am wrong. I just read cursorily. I have not
This was
read it thoroughly. It's not discussed.
neither
Therefore, it
for
is presumed that it is not placed before the court.
both sides.
And now the High Court says, go and do the examination of the land. Now, can you now say that without having this order altered or modified, can you now say that in the earlier survey, 441 land was there? All this has been waived. Principle of waiver and estoppel will come in. When the High Court was passing an order, you did not bring into the notice that this is the fact. Now, please come to this order at page 117.
One second.
In this 117 order, again, please tell me if I am wrong.
My lord.
There's no record of any evidence being recorded when this order objection as to the execution was filed. An objection to execution and disposition of land is covered by 98.
Lordship.
And when you are, and the dictate of the law is that an application under order 21 rule 98 will be treated as a suit.
Section 96 will apply, Lordship.
Please don't interject. Please don't interject.
Lordship.
You suffer an adjournment.
Lordship.
Don't do it. I don't want a running commentary when I'm making a statement.
Lordship,
Please sit down.
Lordship.
I take an offense of that. You think yourself to be very smart?
No, Lordship. Sorry, Lordship.
Then don't do it. Yesterday also we told you that I am absolutely dissatisfied. When the learned counsel is, we are asking a question to the learned counsel. You think it is appropriate for you to reply?
No, sorry, Lordship.
You don't have courtesy to the other side, lawyer? What kind of advocate are you?
Sorry.
First
I'm sorry.
principle of the code of ethics is that you must give respect to the other side. And you don't know even that.
I am sorry, Lordship.
Yesterday we told you and you were there when we took an offense of counsel interjecting when the question is being asked. And you disturb the entire, what you call, the absolute mood of the, when I'm hearing the matter.
I apologize, Lordship. I'm sorry, Lordship.
You will have a right only when it stops. And we tell you, please sit down.
Lordship.
You think it is very easy job? I am looking at records of 40 years. From 1982 to 2000, the 22, records 40 years, records I am looking at. Read the documents and I am putting a pointed question. And you distract me. Yesterday, I had to adjourn this matter only because of the fact that we are looking at a record of 40 years. Two suits, and then multiple applications, multiple Amin commission. You think it's very easy to remember those things? And you distract us. Do it, do my job. Look at the records. We asked you for a list of dates. You did not give it to us. We'll not even hear you. We told yesterday in the order we have put it down. If no list of documents are given, we'll not hear on that point. You will lose the right to make your submissions. I made it very clear that since the records are of 40 years, please give me a list of dates. And Mr. Barwa is kind enough to give it to us. And you and you are not even showing courtesy, telling the court when I have asked for the document, you don't give it to me. We know how to deal with this this innocence. Just because I don't react so fast, don't think that I can't react. You don't assist the court, even despite the order being passed to give a list of dates, you are not giving it, and you just start making submissions. Yes, Mr. Barwa, just give me 2 minutes. I'm upset. Yes, Mr. Barwa.
Proceed refer to order 21, rule 98.
Oh, it will be 99, I'm sorry.
98.
I did it
Disposition of
wrongly.
by decree holder or purchaser.
And the procedure will be 101.
Yes, ma'am. Question to be determined.
Yes. Thank you for pointing it out.
Madam.
Please tell us what you actually want.
My lord, what we want is that, my lord, the learned municip, my lord, learned trial court, my lord. My lord should have, my lord, determined conclusively through a commission, my lord. Commission under order 26, my lord. Because apparently, my lord, there is a drain, my lord, between the suit land and the land of the objector, my lord. And that has not come out, my lord, even from the trace map also. The trace map, my lordship, does not indicate, my lord, clearly, my lord, by the circle officer submitted, my lord. So, the lordship,
We won't comment there, but you see, there is a roadblock. You'll have to overcome that roadblock.
my lord,
If it is a application under order 21 rule 99
yes,
and procedure of 101 is followed,
yes,
then please look at 103, rule 103.
yes, I have seen, my lord,
It's a decree.
decree, my lord.
Now, a decree would mean a conclusive determination of rights.
Yes.
Now, if you want fresh evidence in form of a commission report, that would be only within the meaning of order 41 rule 27 and nothing else. And we are not dealing with appeal.
Yes.
We are dealing with a revision.
Yes. That,
We can't even exercise order 41 rule 27. So and you see the challenge to the commission report is not there.
yes,
The evidence was not led.
not left.
The to call for that and to give evidence was not there. And we have shown you yesterday that under order 40, under order 26 rule 10(2),
Yes.
commission report becomes an evidence.
Okay.
Now, there cannot be a situation where to counter one evidence, we can allow you to give another evidence. That is impermissible under the Evidence Act.
Right.
You'll have to either prove or disprove or not prove. These are the three options available when you are needing evidence.
Right.
But to now pass an order for a fresh commission would lead to a different, what you call the interpretation, because now we will be allowing you in revision,
Yes.
additional evidence. However, that is permissible in law. There is another corollary question here. The corollary question is that in a revision, we are bound by the contours of section 115
Melon.
and order 47 rule 1. Will it permit us to take a view contrary to the one taken by the executing court?
find out the actual position of the,
Any law student here in the courtroom today? Any law student? No, not outside, in the room. You're a law student, please come forward. You're from which college?
Any local.
Any law college? You see, the issue we are now hearing is an objection by the person dispossessed during execution. And so far as procedural law is concerned, this is one of the very intricate points involved here. There are elaborate case laws, but very few from this state. So we are dealing with the provisions of Order 41, Rule 99, 101, 103. Correct? Not for the purpose of this court, but please read those provisions and case laws on the point. You learn many things which you will otherwise miss if you don't do the research after going home. You need not tell us what you have done, but please read this provision, update yourself on the case laws, very intricate issues of law are involved. Regard to possession, dispossession of a person who is alleging that he has been dispossessed while execution of a decree without any due process of law. Correct? Yes.
my lord. Even the page 72 order, my lord, 21116.
Page
Page 72, my lord.
72.
Yes.
Yes.
Here in third paragraph, my lord, the objector petitioner by instant petition assert that land was measured on so and so by the lot mondal as per order passed by this court. The petitioner asserts that Dibrugarh main drain passes by the side of the suit land and the land of the objector. It is further submitted that there is an EMD post on the side of the suit land, showing the end of the land as well as the reserve land of the main drain. It is submitted by the objector that the lot mandal insisted to demarcate.
Just a moment.
Right.
It is submitted by the objector that the lot mandal insisted to demarcate the land from the edge of the drain.
Yes,
And the objector appears that as the land of the objector is only 3 acres, thus the reserve land not detected and not spared by the lot mandal, the substantial portion of land of the objector will go to the reserve land of END. Now we have to ask you a question. Are you aware of the END drain and the what you call surroundings of an END embankment? You have a knowledge of any idea of that? I'll tell you. Whenever there is an embankment, which is either in form of a EMD drain or a channel, then by the side of the EMD drain, there will always be a road or a path, and it is called inspection road. Because water flows, it goes to irrigation and all. Every time it's very difficult to repair. If you have a land near to the EMD, you will not permit them to come in and you'll ask compensation. So to avoid all these things, when a EMD drain is created, there is always a path left on the side of the, after the channel ends and the land in between. You see, a channel cannot be in the drain. The channel has to be in the other side, which is attached to the land, mainland. So there is always an inspection drain if it is an embankment drain. Has to be. And if it is not there, that means some wrong has happened. So therefore, for repairs, renewals, or everything, we have a land and drain. So you are prepared to have it measured from the drain. It's not an acceptable proposition because that is a drain which is within the land of the embankment, is a government khas land. Even if it has been acquired, it becomes a khas land. And I can say so because I am aware of it. The technical information I am having.
Yes, I've seen it. I got an idea.
Hmm?
I got a better idea.
And this is at the site of Ministry of Road Transport and Highways. You see, Mr. Parvat, the issue is very limited. Although it is voluminous, but the issue is very limited. Number one, that 441 was only there in that report. That's something I missed. I could not find out that. What do you call it? Page 46 order at page 49, is I not notice it.
Yes.
That is the only thing in your favor showing 441 with you. But that was not exhibited and no evidence was led. And we don't even know, because you see, once you are saying that you are referring to the land, the calculation of the land from the end of the drain, that would mean that this land which is there, sandwiched land of 441, presumed to be there, and that land is lost. Not by way of execution, but it is lost. Otherwise, in due process of law, because it would have been acquired land. We did not find anything to show that the trace map of that particular dark number 441 showing field HRs.
Yes.
Field HRs would be 144 into 3. 400 something
Yes,
square feet of land. It's okay, it doesn't prove like 400 to 500 feet of land. So this having not been challenged, that evidence already on record by form of a commission report pursuant to the High Court order. No option but to dismiss your application. Anything more you have to us?
my lord, that map submitted by the circle officer to the court. Page 98 is the type copy, my lord. Page 99, my lord.
99.
My lord.
99 is that trace map.
Trace map.
Ah.
There, my lord, Schedule A land is shown, my lord, decretal land. And Schedule B is the objector land. And public drain is separately marked.
Do you have a copy of Jamabandi here showing your land?
I have, my lord. Page 91.
91.
Yes. Type copy, 92 is the. It's in the name of petitioner father. Mohammed Rauf and Mohammed Hamid. Chapter number 159.
This dispute started in which year?
From the 2007, month, when the exhibition was done, my lord, then only. wrongfully dispossessed.
What is the date of execution?
My lord, 19, 1980. 14 July 1982 execution order was in force.
No, the date of execution, according to you. When were you dispossessed?
Yes, my lord, that is in page 33.
Just tell us.
Nazir went to civil on 23/7/2007. Nazir went to the site and dismantled the house. 23/7/2007 in page 34.
It was a thatched house.
Yes, in treeless outlet.
You have any photographs before the demolition?
Some photographs are there, my lord, page 96.
That is after demolition. You have a photograph of the structure which existed before alleged demolition?
Or else, my lord, page 93 maybe, my lord. Page 93. From revenues, staff went there.
You have the copy of the commission executed for finding out the land? You have a copy of that report here?
Report.
One which is favorable to you,
That report is not there, my lord.
not there.
Not there.
And the report which is against you,
That is page 102 onwards. Type copy 100.
Against this report, page 100, what did you do?
Against this, my lord,
You went for RTI.
yes, RTI. RTI report came, madam.
Mr. Barua,
Well,
whatever was in your favor,
my lord.
discarded everything. In this page 100, you made us read. There's a reference to tag number 441 and the Nazir says we have shown him that land, but you don't sign it. The existence of the land which was shown to you, you did not sign. But he made a statement that there's no T&D drain next to that. So he found out your land,
Yes.
and this you did not sign and accept. It says, so that two pata three lechas in schedule B and the pata number so and that number 3441, area of 3 lechas has been measured by the Union officer staff of the circle office along with the civil nazir and boundary and are shown to both party in aforesaid measurement. The first party put its signature, whereas second party objected and refused to put signature. So when you are shown the land, you say no.
That E&D drain under which that falls.
That means you don't know your land. You have constructed your house somewhere else.
Page 103, my lord, the type copy of the report says that we, last three line, my lord, while measuring, we do not find E&D drain in the map.
Indian drain is not there. So you see what has happened is that you are occupying some land and you think that is your land 441, whereas your 441 is somewhere else. They were showing you the land and you don't take it. You are insisting that your land is there in the END drain. In the END drain, they find no land there. When they are showing you, finding out 441, giving it to you, and you say, no, I don't sign it and don't take it.
But in the earlier suit they filed, madam, that was there, madam, in the house. But that brings,
You were offering that land, see, this is your land being offered. You did not take it. Now in the process, you lose everything.
so my land somewhere must be there, madam.
But they had found out.
And that could be, my lord, in my humble summons, if the commission, they appoint my under order, then
The commission is not required. The allotment knows how to measure a land.
basically that E&D is the, my lord, issue, my lord, whether it touches the suit land and the land of the person.
Sitting in revision, we can't find out your END land.
And the learned executing court, my lord, says that executing court has no power to order such restoration. The concluding remark, my lord.
Definitely, if the land is not found to be dispossessed, 98 will not, 99 will not apply. You will have no power to grant that land. You have to find out the land from where you are dispossessed. The exercise were done. You don't sign the document, you did not sign the document in dispute. And you could not, Move that. But Mr. B. Barwara is also for the Krishna. And he shown them for the respondents. Next. By filing this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 2/5/2022, passed by the learned Munsif number 1, Dibrugarh, within bracket, as it was then, bracket closed, in title execution case number 49/1982. The respondent, respondents are the decree holder, where is the key? The, the, the predecessor in interest of the substituted respondents, number 1A to 1D, and both these 2, 3, and 4, respondent numbers 2, 3, and 4, they are also degree holders.
Yes.
Oh, this is the interest of the substitute of the respondents with the degree holders. Next one. A brief background of the case is that one Chenia, 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 Srimati Chenia Teli, Teli, and her 2 sons, namely Anak Anat, Anak Ram Ram Teli, and Shiv Kumar Teli, had filed the TS number 27 of 1981 against one Dwarka, DWARKA Prasad, PRASHAD, BIN, and 6 others for recovery of khas possession of the soup land measuring 30 feet into 11 feet, being part of 3 Katha land covered by Dag number 436 of Pata number 158, situated at Kalibadi Road, Marwari Patti, MARWARI, Patti, Dibrugarh. Which is more fully described in the schedule B of the plain. The said suit was decreed party by judgment and decree dated 14/7/1982. The decree holders instituted execution proceedings, which was registered as title execution case number 49 of the 1982. The decree was executed as recorded in the order dated 16/6/2007. Not disposed of. Mr. Execution Positive was insurance also. On the strength of the decree, the civil Nazir visited the site on 26/2/2007, and despite objection by the petitioner, the house allegedly standing on 3 acres of land covered by dock number 441 of Pata number 159 was demolished. Accordingly, the petitioner filed petition number 1972 of 2007 on 18/8/2007, alleging that alleging disposition of the petitioner from the petitioner despite not being a judgment debtor. The learned executing court by an order dated 12/5/2008 directed the civil Nazir to visit the site along with the revenue staff of the concerned revenue circle for measurement of the land and to submit a report. Resisting the implementation of the said order dated 12/5/2008, the decree holders approach this court by filing an application under Article 227 of the Constitution of India, which was registered as CRP 239 of 2008, and this court by an order dated 13/5/2015. Allowed the verification process in terms of order dated 12/5/2008. The operative part of the order operative part of the order contained in paragraph 11 and 12 thereof is quoted below. Page 62, paragraph 11 and 12. You have to copy this. 11. Bereft of avoidable details, it would suffice to mention that the certain officer, having conducted the survey as directed, submitted a report dated 18/6/2016 before the learned executing court. Among others, mentioning that land in Schedule B under Patta number 159 and DAC number 441 with area of 3 Lecha land had been measured by the then official staff of the circle office along with the civil nazir, and thereafter boundary of the land was shown to both the parties. While the decree holders put their signature to the said report, the petitioner refused to put the petitioners refused to put their signature on the said report. Next. Thereafter, the petitioners had moved an application hearing petition number 1982/16. It's a prayer before the learned executing court to direct the flood control department to demarcate the land jointly with the lot holder. The learned executing court by an order dated 2/11/2016 rejected the said prayer. In the meantime, pursuant to orders passed by the London Executing Court, the learned counsel for the petitioner has submitted that trace map of the concerned plot of land was obtained. However, on a perusal of the said trace map, which page was that? That's at
99.
399. This is available at page 99 of this the petition, and at page 34 of the file A of the records of the executing court, chart number 441, measuring 3 lesser land, is shown to be sandwiched between land covered by dark number 442 and four three six. And in the original trace map, the land covered by dark number 441 is marked with color green. See, bottle green. There are two green here. It is Ajit. It's a green, but it's a green as well. It's green as well. No, please, the blue. The blue is the green. This is blue, right? It is blue, right? What did I do? What is right? What should I call this color? It should be bottle green because there are two colors. You can't distinguish between the two. One would be light green or it is light blue. So you don't make a mistake in the order. Please, please do it. Please, please do it. What is right? What should I call this color? It should be bottle green because there are two colors. You can't distinguish between the two. One would be light green or it is light blue. So you don't make a mistake in the order. I've called it bottle green. Is it correct or? So there's another green down there.
Seems like sky blue, maybe. Sky blue type color. Sky blue type color is.
Yes. So bottle green is okay.
Yes.
Refer you. Something like pastel green, pastel green.
Pastel.
The other green is pastel green. I'll just take a break and come back. Petitioner has submitted that land measuring 3 deshas covered by dark number 441 was situated adjacent to the E and D, capital. Drain. For which reference is made to the judgment and order dated 30/11/2012 passed by the Court of London Munsif number 1, Dibrugarh, in bracket, as it was then, bracket closed, in title suit number 8 of 2008, which was filed by the decree holders against the petitioners. Where the reference of land covered by chart number 441 of PP number 159 was referred to. Next part. So the learned counsel for the petitioners has also referred to information received pursuant to an RTI application you are referring to page 109 for what purpose? The RTI reply you referred to yesterday.
Yes, sir. That is in 2017.
Yes, what was the purpose of relying on it? Yesterday you made submissions here, I forgot.
Here it was mentioned, Melon Para 1, 2 Kotha 3 Lessa of land.
Yes. That number 436.
Yes.
So, what do you want to convey with that
I want to
reference?
convey that That they says, well, as per the RTA says that in dark number 436, 3 katha have been found. And these dark number do not contain 2 katha, 3 lesser. That is page 100 report of circle officer is
Okay.
somewhat contrast.
RTA replied dated 5/4/2017, wherein where next word in paragraph 1 thereof, the circle officer, East Revenue Circle had disclosed that under Dibrugarh Town Moza Marwari Patti, Patta number 158. But just say it like this, not that. Just that 3 katha land was found in dark number 436 of Patta number 158 at in Dibrugarh Town, Moza, Marwari Patti. And the aforesaid dark number does not contain 2 katha, 3 lachas of land as per record. So accordingly, it is sought to be projected that 3 lachas of land, which is from which the petitioners have allegedly being dispossessed, is found to contain within dark number 436, correct? So accordingly, it is submitted that the impugn order dated 2/5/2022, having not taken into account the said RTI reply, which is contrary to the demarcation made on 13/6/2015, which was forwarded to the learned executing court by the by the circle officer, Dibrugarh East Revenue Circle by letter dated 18/6/2016, was incorrect, and therefore he prays for a fresh demarcation of the land by setting aside the impugn order dated 2/5/2022. Mr. Barwa, we have left out anything? Okay. Next. From the to say that having heard from both sides, the execution records received from the Court of Learned Munsif number 1, being records of title execution case number 49 of 1982 has been perused. Next. It is noticed that in the judgment, dated 30/11/2012, passed by the Learned Munsif number 1, Dibrugarh in PS number 8/08. The case projected by the decree holders was that they were absolute owners of a plot of land measuring 3 katha covered by tag number 436 under PP number 158 and situated at Marwari Patti ward, and another land measuring 2 katha 3 lecha covered by tag number 332/703 situated at Kalibari Road, Marwari Patti ward. Full stop. While discussing issue numbers 3 and 4 of the said suit, the learned trial court had referred to the spot verification report of the circle officer that the hatchet house fell in dark number 441 of PP number 159, 440 of dark number PP 207 and not under dark number 436 of PP 158. And further referred that the same was affirmed in the cross-examination of DW1 and the DW1 had disputed land in dark number 441 of PP number 159. It would be appropriate to quote the decision of the learned trial court on issue numbers 3 and 4. Quote from page 48. Blue pencil, sorry, red pencil mark. And 49. Full stop. Incidentally, comma. The suit filed by the decree holder was dismissed. Full stop. Next, however, comma, when the matter relating to the joint, the site verification was being adjudicated by this court in CRP 239 of 2008. When the order dated 13/5/2015 was passed, disposing of the said CRP 239 of 2008, the order does not reflect that the judgment and order dated 30/11/2012 was brought to the notice of this court. It is apparent that even after disposal of the split CRP 239 of 2008, no application has been filed for any omission on part of this court to refer to the finding on issue number 3 and 4 in the judgment and order dated 30/11/2012 passed by the learned trial court in TS number 8/2008. So therefore, a fresh survey of the disputed land was carried out. As indicated above, in the process of demarcation, it does not appear that the judgment and order dated 30/11/2012 passed in TS 8 of 2008 was referred to. In the demarcation so carried out, on 13/6/2016, which was forwarded to the learned executing court by a letter dated 18/6/2016, issued by the circle officer from East Revenue Circle. Dark code by the land covered by dark number and land measuring 3 lecture covered by dark number 441 was shown, which the petitioners have refused to accept. They are refusing to sign the report of the circle officer. As indicated earlier, in the trace map, evidence file A of the title exhibition case number 49 of 1982. The land shown at dark number 441 is found to be sandwiched between land covered by dark number 436. So we see triangular shaped land triangular shaped land is found sandwiched between dark number 44436 and dark number no, I'm sorry, it's not triangular. Not triangular. The land constituency is found sandwiched between the land covered by dark number 436 and four four two. However, in connection with the Schedule B land covered by measuring 3 lesha covered by dark number 441 of pata number 159, comma, it has been mentioned in the said survey report that the said land was shown to both parties, but while measuring the concerned land revenue staff did not find E and D drain in the map. Full stop. Next, in connection with the proceedings which arose out of petition number 1972/2007, would be deemed to be an application within the meaning of Order 21, Rule 99 of the Civil Procedure Code, comma, no evidence was led by the petitioner to show the existence of that of dark number 441 to be the land from which the petitioner was allegedly dispossessed. Next one, thus, comma, though land, the 3 lesser land of tract number 441 was told to the petitioners, but they refused to accept the said land. Apparently insisting that the land would be next to the E and D grade. Next, under the circumstances, the court has no material on record to dispute the, so as to disbelieve or so as to disbelieve the finding recorded by the learned executing court. You said the name of, by the learned receipt number 1, Dibrugarh, the passing order dated 2/5/2022. Next, accordingly. There is no apparent reason for the court to take a view contrary to the one taken by the learned receipt number 1, Dibrugarh, in the order dated 2/5/2022. Next up. While entertaining this challenge to the present challenge to the order dated 2/5/2022. This, which is filed under Article 227 of the Constitution of India, the court is only exercising supervisory jurisdiction. And unless any error apparent or any jurisdictional error is shown, the court would not substitute its view with the one taken by the learned executing court. Next, resultantly, the challenge to the order dated, impugned order dated 2/5/2022 fails, and this revision is dismissed. Next one. Having noticed that not say anything. This next time you see it. The no, just like next after that. Put on record a precision of the court towards the assistance rendered by the learned counsel for the petitioner, whereas the court was to deal with the record of 40 years. This court, by an order dated 13/5/2026, requested both sides to give a list of dates which was complied with by the learned counsel for the petitioner. However, similar assistance is not found to be forthcoming from the learned counsel for the respondent, which is deprecated. But
Okay.
Oblige, Your Lordship.
Upgraded item 23.
Hello,
There is
my
a-
learned
there
friend
is a
is charged.
technical difficulty, Mr. Sheikh.
Allah,
In your matter, there is a technical difficulty.
Allah.
You come to your IA first. You come to your IA.
Yes,
First,
my lord.
first title.
55,
Yes, 55.
my lord.
First title, first title.
Sofia Khatun,
No, first title is an application under.
Jahanara.
No, an application under.
Oh, application under Article 226.
Article 226 is not for modification of the order passed in CRPIO.
It should be 227, my lord.
That also is, you can just say an application for modification, but why do you use 226?
My lord, it is
Technical
wrongly,
difficulty.
wrongly typed, my lord.
The technical difficulty.
Uh-huh.
But still, yes, what do you want to say?
My lord, actually, they have filed a case for vacation of the interim order,
Yes,
which was granted in CRP IO number 341.
yes.
Now, my lord, if that order is vacated, then the entire case would go. Instead of that, my lord, I propose that entire matter may be heard. Main case may be heard.
We don't even know what has happened. What is the order against which stay was granted?
Stay was granted, my lord, against the order of the Learned Bunship Borpeta. But here is a case where the decree has been obtained against that person. So decree is a nullity. On those points, I will argue whenever the case comes. So main case may, what my learned friend wants that it should be vacated. But if it is vacated, then my whole case will go. So let the
So let Mr. Sheikh say, then we'll decide whether hear the entire thing or with the part of it. Because yesterday, Mr. Sheikh told us that decree passed long back was being stayed.
yes, that is true. Because, but at that time, my lord, the Learned Bunship decreed the suit when the parties were allied. But when the first appeal was filed, party dead. Even then, against that person, they filed the first appeal. Then again, they came to second appeal. Second appeal also they filed against some dead person. So first appeal and trial court, we own the case.
Just let me understand. Mr. Sheikh's client had died.
When it was during the trial court,
Who died? Mr. Sheikh's client or your client?
and my client.
Oh, no, then he is not, he can't be, that point would not have any merit. The reason is that you did not put the petitioner to notice of the death. So this will be a case where you'll have to inform about the death and
Yeah,
then.
that was done. That was done and parties live side by side.
No.
And they are co-wife.
He may be, Mr. Sheikh may be a good man. He does not know the next party has died. He does not want to
Co-wife.
know the other side has died.
His client and my client are co-wives. The same person.
So maybe, but when,
So-
when two people fight, they may not look at each other, does not know he has died.
And that is next to impossible matter. Because
We don't know.
this
Strange
is
world.
between the two co-wives.
It is strange world.
So my submission is that the decree is nullity and we will prove that. So main case may be fixed for hearing. Otherwise, if the vacation order is
Here,
passed,
there is nothing on record in this CRPIO that you brought to the notice of the court that the party has died. This I did not find, but I don't read it so thoroughly, I may have missed it. This shows in the record of CRPIO that before the first appellate court, you informed the court about the death. I was not knowing about this submission, so I did not read it that thoroughly.
here are 1IA 3946/25. That was filed by Jahanara Begum. And this present appeal is also filed by Jahanara Begum, who is the second wife of late Abdul Rauf, who is the main party here. So 341 is the main case. Their lordship would say page 11 onwards. And there is also observation of the Honorable High Court that order lordship I have annexed in the CRP IO that may be seen, my lord, page 66.
Who is Jahanara? You are Jahanara.
I am Jana, second wife, and Sifia is the first wife.
This is for review. 1 to 3 days of delay on filing review applications.
Kindly see page 68. It is from 67 bottom. There are two.
Para?
There are two, 67. The learned counsel appearing on behalf of the applicant submitted that prior to the judgment and decree passed by this court on 30/11/21 in RSA number 46, 2014, the resolution number 2, 3, and 12 in RSA number 46, 2014 had expired, and as such have filed this review application. He submitted that the judgment and decree passed by this court dated 30/11/21 in RSA
Therefore-
number insofar
only
as
at the-
RSA number.
Therefore, only after the judgment was passed, then you are informing the court that person has died.
No, my lord. First appeal was filed. At that time, he filed the first appeal against some dead person. In the first appeal, even then his appeal was dismissed. And
On the ground of abatement.
no, on the ground of merit. So,
But that's why we are asking you, see, when, was it contested by you, the first appeal? No,
yes, contested.
contested. So where is anything on record to show that you brought to the notice about death of a person and discharge your obligation under order 22 rule 10?
No, that is why, my lord, I am submitting that the main case be fixed for final hearing instead of going to the IA. That I will bring everything before our notice.
Make your submissions. Who is the petitioner in the IA? No, in the main petition, who is the petitioner?
I am the petitioner.
CRP. And which is the order impugned?
Impugned order was S45.
Page 45 can't be impugned. In CRP, I would not touch this order.
No,
But
this order was passed. This order was passed
Please tell us
when
where
the
is the impugned
person
order?
died.
Please tell us where is the impugned order? Which order is under challenge before us?
No, they have challenged the order that is page 37 of IA.
No, you are the petitioner in CRP.
Yes,
Which is the order under challenge?
yes, that we have challenged, my lord. Actually, challenge was in that manner that there was a petition filed under section under
Please show us which
order.
order.
Let
Please show us the order. Which order?
my lord, let me submit. My lord, we approached the Honorable High Court, High Court asked us to file an application under Order 47 before the Executive Court. Then we filed the petition, but Executive Court took times after times and finally did not pass order. And in such a situation, my lord, we have filed a petition that all in a sudden that
Mr. Mahmood, you see, you are filing this application
Yes.
under Article 227. No, you are filing in this application under 115.
115.
So under 115, what is the order and the challenge? I am asking you a simple question. And now you say that there is no order impugned. Your prayer in this application is that please stay the execution. It's not maintainable.
That was passed as per order of the Honorable High Court.
We are not
High
concerned
Court
with
says
that.
that you file petition and that shall be disposed of by the Executive Court.
In 115, we can't do that. Jurisdiction under 115 is demarcated within the contours of 115. We are not the original authority to pass an order in execution case.
No, we can file or not, that is what we file this petition.
This
As
is the
per order
matter.
of
This
the
has no
Honorable-
merit. Mr. Mahmood, this has no merit. We have no jurisdiction to do so under 115.
But that was passed by the,
You do whatever remedy is available, but 115 will not be exercised to stay. If the court has not done, then you have other remedies to enforce that order, but not by way of an CRP under 115.
that may be seen page 104. 104 onwards. And finally, there's kindly see so many dates were taken, no order was passed. And
We
finally,
have remedies for that. But to ask this court to stay execution when no order is under challenge, impermissible.
order is under challenge, my lord, because they did not, the learned Bushi passed the order. Passed the order first. Then passed an order that
Mr. Mahmood, you know, in a lighter note,
actually, my lord, I was on
I'll
IA.
tell
I
you.
was on IA. I was not prepared for main case because IA is fixed today. IA is fixed today.
in this bench, at the motion stage, you must be ready for hearing. At the admission stage, you must be ready for hearing. At the order stage, you must be ready for hearing. And when it is listed for hearing, you should be again prepared.
That is another matter, my lord. But when the case is, IA is fixed, then we are prepared for IA.
You made a prayer that please upgrade and take up the hearing. You are taking up the hearing now.
No, hearing, I definitely prayed, but not today.
No. That can't be. You don't have a choice.
But
You
it
don't
is
have a
not
choice.
listed today for hearing.
You'll take it up. That you can challenge that order. But
On the four men there.
no, it's not that. You see, we are hearing this.
Court.
You are not permitting us to do the hearing in the IA, saying that the main matter should be taken up. You have taken up the
No,
main matter.
I have definitely said, but on another day,
At
that
best,
will
we
be,
can adjourn it. to
maybe
2 o'clock.
on the next week, I have
We
not.
can, you can take it up at best at 2 o'clock.
Next week, any day.
No. We don't apply our mind and then say adjourn. We asked you a question, you gave a response. We asked you another question, you gave a response.
Then let him argue. Let him argue.
No, it's your turn now. You're taking up the CRP.
No, today IA has come.
You don't have a choice, Mr. Mahmood.
No, it is listed. I am not taking my choice. It is listed. It is listed IA for today. In
We
CRP.
have heard him. We have heard Mr. Sheikh. His
Just now it is called when your lordship has heard. I don't
work is over. We have heard him. Now please respond. Mr. Sheikh has nothing more to argue.
And your lordship may pass any order. Because I wanted that main case we had in another day. Anyway, I am not taking time. Because today main case is not fixed for hearing. So necessarily I did not prepare accordingly. So I will definitely argue any day in the next week.
No,
any
sorry.
day.
You want us to pass on orders, we do so. But we put you notice on the second time. Do you want to make your submissions?
I have, main case I have not prepared. I will let it be taken at 2 p.m. Let me try.
Okay.
I can help to some extent.
Yes. This is item number 4.
Here, my lord, if your lordship may kindly go one of the provision of law, kindly see order 22. I starting while conclude at 2 p.m.
Yes,
if your lordship so desires.
yes.
Now order 22, 4. Proceeding in case of death of one of several defendants or of the sole defendant, where one of the two or more defendants dies and the right to sue does not survive against the surviving defendant or defendants alone, or a sole defendant or sole surviving defendant dies and the right to sue survives, the court on an application made in that behalf shall cause the legal representative of the deceased defendant to be made a party and shall proceed with the suit. So they have not prayed anything to implement the legal representative of the party. Then any person so made a party may make any defense appropriate to his character as legal representative of the deceased defendant, wherein within the time limited by the law, no application is made, either subject 1, the suit shall abate as against the deceased defendant. So if the suit is abated, then where is the decree?
What is the date of death?
Date of death.
Okay, I have to rise.
On 22, 5,
I will continue at 2.
2. My lord, first I want to say a few points on their IA.
Yes,
They have filed the IA under Article 226.
yes,
Now, your lordship has said that it will lie under 227, perhaps my landed friend also said. Now, question is this, whether this court can exercise its jurisdiction under Article 227 in respect of another order of the High Court. My points may kindly be noted down, madam. Because they have challenged the order which may be seen page 38 of the IA.
yes.
This order has been passed by the High Court and they have challenged that order. They want to set aside that order. Now 226 does not lie. So far 227 is concerned, let me read this. Power of superintendence over all courts by the High Court every high court shall have the superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. So, all courts and tribunals, to my humble understanding, does not include the High Court.
Yes.
So, their petition may be dismissed at levain on this count alone. Now, here, petitions, IS may be seen, page 1, page 1. It is Jahanara Begum. Then page 2, present address, village Kukarpa. Dasmati, post office Khongra, PS Satyabari, district Borpeta, Assam. And her address is village Kukarpar, post office Khongra, PS Satyabari, district Borpeta, same village. And they are close door neighbors. And co-wives of late Abdul Rauf.
Yes.
Now kindly come to order 22, rule 3.
Yes.
Where one of the two or more plaintiffs dies, sorry, madam, that it will be 3 for plaintiffs, 4 will be for defendants, 4. Order 22, rule 4. Where one of two or more defendants dies and the right to sue does not survive against the surviving defendant or defendants alone, or a sole defendant or sole surviving defendant dies and the right to sue survives, the court on an application made in that behalf shall cause the legal representative of the deceased defendant to be made a party and shall proceed with the suit. Now, here, my lord, the defendant has died. Not only one, 3 defendants have already died. One is principal defendant, Abdul Rauf. Secondly, Hayat Baksha. Thirdly, Hazrat Ali.
You have respondent numbers?
Their respondent number let's see page 17 of the CRBI.
No, just tell me this, their serial
Uh,
numbers as defendant.
Defendant number 2, Abdul Rauf is defendant number 2, and Hayat Baksha is pro forma defendant number 11. Hazrat Ali is pro forma defendant number 2.
Yes.
So, this Abdul Rauf, Hazrat Ali,
You have the date of death?
yes, their date of death, that may be seen, my lord.
Just tell me.
Abdul Rauf died on 22/5/21,
Yes.
and Hayat Baksha died on 28/2/21.
He is pro forma respondent too.
promotion, no, his promotion number
11.
11.
When did he die?
He died on 20/2/21.
28.
Yes, 28,
21.
28/2/21.
Yes. And the third one died when?
And third one died much earlier, that is in, perhaps in 2003. That means he died in 2003. Before filing, even the title should, let me. His date of death exactly not known, but he died in the year 2003. Page 8, para 7. So, before the first appeal, he died. And before the second appeal, Abdul Rauf and Hazrat Ali died. Now, let us go to order 22, rule 4.
You have already read that.
Yes. Rule 4.2, rule 4.2,
You've taken note of the provisions of law.
I am going to provisions of law first, then I will say some facts.
No, we have read that. When you were reading it, we read it, that order 22 rule 4.
No, here is no, in order 22, there is no any such thing that plaintiff or defendant has to inform. It is not there. That's why I am saying, what your lordship asked me at the first half, let me see.
Please don't read it. No, please don't read that. We have read it. I have told you that we have read it. You make your permissions.
I am submitting, my lord. Where? Order 22, rule 5.
Please,
Where the
kindly-
plaintiff was ignorant.
kindly listen to me. Please don't put the provisions of law. Just refer to it and we'll understand. Order
Because
22, I've been reading for last 30 years. Please tell me the provisions, that's all. You don't, unless you have something specific to explain the law, then it's different.
it is very
Yours-
important, it is very important for this case matter. That's why I am submitting. Because here, Mali, it is very much clear, if the plaintiff was ignorant of the death of the defendant, what your lordship quoted the first half, then, and could not, for the reason, make an application for substitution of the legal representative of the defendant under this rule within the period specified in Limitation Act, the suit has in consequence abated. So that is abated. However, it is in B, it is said that the plaintiff applies after expiry of the period of specified thereon in the Limitation Act for setting aside the abatement and also for admission of that application under Section 5 of the Act on the ground that he had, by reason of such ignorance, sufficient cause for not making the application within the period of specified in the Act. The court shall, in considering the application under the Section 5, have due regard to the fact. So, my lord, he did not file any petition. She did not file any petition. That I was unaware about the death of Abdul Rauf, Hazrat Ali, or Hayat Box. So he did not file any application. Till today, he has not filed application. So, as in view of Order 22, Rule 5A, her case is abated. Now, my lord, the RSA 45, RSA number 46, 2014. In the year 2014, the RSA was filed. And principal respondent defendant died in the year 2021. He got the order, in RSA, he got the order, that is page 45. He got the order on 30/11/21. 30/11/21, page 46. Now, my lord, on that day also, he did not file.
Yes, please continue.
My lord,
Please continue.
page 46 of CRPI.
Yeah, yeah. Yes, without that, I see, agree.
Yes.
Page 46, operative portion. The Honorable High Court passed order on 30/11/21. Allowing the second appeal. Here, my lord, I want to apprise your lordship that in the title suit and in the first appeal, her case was dismissed.
Yes.
Lordship has realized the point that in the trial court, as well in the first appeal, her case was dismissed. Only in second appeal, her case was allowed. Decree was passed on, judgment and decree was passed on 30/11/21. And against whom the decree was passed? Mainly against Abdul Rauf. And this Abdul Rauf died on 22/5/21. That means much earlier than the judgment and decree was passed. Perhaps I could realize your lordship that what I am submitting, my lord.
Yes, yes.
So the order was passed on the day, that means nearly 6 months earlier, the principal respondent died. And main decree has to be executed upon that person. And he has 2 wives, living wives, children also from both the wives. They were not made party. Even Sufia Khatun, the present applicants, has also children through Abdul Rauf. So they were also the legal representatives of Abdul Rauf. She knows very well. And that is Jahana Begum, has also children through Abdul Rauf. So they are the legal representatives. They were not parties, even on the day when the judgment and decree was passed by this Honorable High Court. So the judgment and decree was passed against that person, which is evidently nullity in the eye of law.
Please complete your argument.
Yes. Now, kindly see section 121 of Limitation Act. 120. The legal representative has to be, she knows all this, 90 days they have to meet parties. And if not met, after 60 days, the suit will be abated. From all sides, the suits have been abated. And decree is not executable. Now, let me see their title suit matter. Title
Mr.
suit.
Mahmood,
Well,
you are wasting the time of the court. Then why don't you do this? If you want to waste time, you read from page 1 till page 100. That's all. Why are we required to look at the plaint? It's not your case that in the plaint, the issue of death was raised.
those are pertinent questions for me. However, let me finish. This is my last point that would be. Eviction is sought for from two lessons of land.
We are not concerned. You are asking in your revision, what is your petition? What is your prayer in your revision?
My prayer was that
Please stay the proceedings. You are not challenging any order, and you are unnecessarily making us read all these things.
order was not passed, killing time in the bylaws. It was the
Why are we required to look at our order 22, rule 4 and 5, or article 120, article 121, which you are referring to?
because they have filed a petition on that issue. So only they said that from two lessons of land they want to evict that. So if your lordship is on that, I hope that your lordship would clarify that point. Otherwise, what will be an entire house they may try to take by this using the order of the honorable court. Decree should be executed in accordance with the strictly it's for provision of title suits, that is Schedule C. So that is my submission.
Can any of both of you assist us in telling us what happened to the section 47 application?
Well, that was filed as per Honorable High Court order.
We understand, but can you both of you assist us in telling us what happened to the 47 application?
Since they are filing this case, no order was passed. If thereafter anything is passed, my landed friend may say, I have no idea.
But may I say, Mala, that 47 petition is pending, Mala.
Still pending.
Yes, pending before the executing court, Mala. And that petition was filed. Mala, background is like this. my learned friend filed a review petition against the order passed in the judgment passed in the RSMLR. So your lordship, in the said review petition, he filed a limitation petition. Then your lordship made a query whether Mr. Mahmood can agitate this matter under section 47 before the executing court. And ultimately, my lord, the Mr. Mahmood, my learned friend, my lord, said before the court, before your lordship, that yes, I will file appropriate petition before the executing court. So ultimately, my lord, that petition has been filed and that has been registered, and till date that is pending before the pending consideration before the court below, my lord, that executing court. In the meantime, my lord, this revision petition, this CRPIO is filed before your lordship, and my learned friend obtained stay. And what happened, my lord? After going through again, when the case came before your lordship, then your lordship found that that petition, 47 petition, under section 47 petition is pending. So your lordship passed an order that stay is not necessary, because that petition, when that petition is pending, execution will not be done. So that stay order was vacated by your lordship. After that, what happened, my lord? Again, he filed a mistake.
Where is that order of vacating the stay?
Vacating stay, my lord.
Which
Yes,
stage?
I am giving it. More petition to. Your lordship would be pleased to take my petition, my lord.
That 55.
55 minutes, case. So your lordship will go to page 32.
Page
32 of my miss case, my lord. IACB 55. Page 32 to 35.
Yes.
It starts from 34 most,
Okay, I've read it.
my lord. So, my lord, the state granted in the execution title execution order dated thereto is hereby vacated.
Yes.
So, my lord, thereafter what happened, my lord? My learned friend filed another petition, IA. That IA number was registered at 3946 of 2025. And after that, my lord, another stay has been obtained. Another stay of the executing court. And I filed this, my lord, for vacating that is. That is the position. My lord,
Okay.
thing is very simple. On the basis of High Court direction, my lord, my learned friend approached the executing court. And executing court petition is pending. Where is the question arises of another petition before your lordship?
Okay. Heard. In the, take this order in this, CRPIO, 341 of 2025. Next one. But Mr. Emil Mahmood, learned counsel for the petitioner, as well as Mr. M.A. Sheikh, learned counsel appearing for which respondent?
My lord.
Respondent number one. Respondent number one. Respondent number one. Next one.
No.
Only one, so.
Others were not paid party, my lord.
Sole respondent. This application to this petition under section 115 of the CPC, read with order 21, rule 29 of the CPC. is one of the classic examples of how by approaching the court, an execution petition can be delayed. It would be appropriate to mention that in connection with this petition, IA Civil 55 of 2026 was filed for vacating the stay. In connection with consideration of the said IA Civil 55 of 2026, the learned counsel for the respondent had stated that if the prayer made in this said interlocutory application is considered and the stay is vacated, it would permit the execution to proceed. So therefore, since execution of a decree was stayed, despite initial objection by the learned counsel for the respondent, this revision petition has been taken up for hearing. Next paragraph. The background facts of this case is that the respondent had filed a suit before the learned trial court seeking declaration of a right, title and interest over Schedule B land, semicolon, for a degree of khas possession in respect of the Schedule C land by evicting the defendant numbers 1 and 2, semicolon, for permanent injunction, semicolon, for partition, etc. Full stop. The said suit was dismissed.
Yes, ma'am.
Full stop. Agreed by the dismissal of the suit by order dated 1/2/2006, the respondent number 1, i.e., the plaintiff, had filed title appeal number. What is the number? I'm not getting that number.
2006.
2 of 2010.
2/2006.
But two oblique 2006.
2006. 2006. However, the said appeal was dismissed by the learned district judge from Gauhati by an order dated 21, order and judgment and order dated 21/12/2012.
Yes, ma'am.
Full stop. The aggrieved respondent number 1 preferred a second appeal which was registered as RSA 46 of 2014. And this court by judgment and order dated 30/11/2021 set aside the decree of dismissal passed by the learned trial court as well as the learned first appellate court. And the suit was decreed. Full stop. Next part. In this petition, the case projected by the petitioner is that when the judgment and order dated 30/11/2021 was passed by decreeing the suit by this court in RSA 46 of 2014, defendant number 2 had already died on 22/5/2021. Full stop. The defendant number 3, Hazarat, Hazarat, Ali, had died in the year 2003. And the defendant number 12, Hayat, Hayat, Boxa, Boxa, had died on 28/2/2021. So accordingly, it is projected that the decree was drawn against a dead man and therefore a dead person and the persons, and therefore the decree was a nullity. Full stop. In this context, the learned counsel for the petitioner had referred to the provisions of Order 22, Rule 4 and Order 22, Rule 5 of the CPC, as well as he had referred to Article 120 and Article 121 of the Schedule to the Limitation Act of 1963. Full stop. In course of submissions, the learned counsel for the petitioner had expressed apprehension that in guise of executing a decree, though the decretal land claimed was how much? 2 lesha.
For eviction.
For eviction. But there are reasons to apprehend that the petitioners may be evicted from their entire landholding. Next one. In the context of the death of the respondents, the defendants referred above, the learned counsel for the petitioner had submitted that the petitioner and the respondent number 1 and the sole respondent are both wife of late Abdul Rauf, and they reside in contiguous houses. contiguous oblique neighboring houses. And therefore, the respondent was well aware of the death of the said respondent numbers. Oh, sorry, the said dependent numbers 2, 3, and 12. As per the parties referred to in the cost title of RSA 46 of 2014. Next. I just have a question. In this title appeal, the first appeal, it is the first appeal. Was it ex parte or you had contested the said first appeal? Contested. Okay. On a query of the court, the learned counsel for the respondent has submitted that in the proceedings of the title appeal, which is the first appeal under section 96
But
of
at
this,
that time, Abdul was alive.
comma, stop. You said that he was contesting. Huh? Stop. It is submitted that at that time, when the first appeal was being contested, the respondent number 2 in RSA 46 of 2014 was alive, but the respondent number 3 and 11 had died. Stop. In this revision petition, there is no document on record to show that the learned counsel representing the respondents, specifically respondent number 3 and 11 had discharged their duty and obligation prescribed under Rule 10A of Order 22 to communicate to court the death of a party. Full stop. Therefore, it appears at this stage that the issue whether the respondent knew about the death or not is merely a matter of presumption that since they live nearby, it would be presumed that the respondent was aware of the death. Full stop. Therefore, full stop. Similarly, it is during the pendency of RSA 46 of 2014 which were decided on 30/11/2021, comma, the defendant number 2 had expired on 22/5/2021. However, in connection with the proceedings of RSA 46 of 2014, comma, nothing has been brought on record in this revision petition that the learned counsel representing the respondent number 2 had discharged his obligation and duty prescribed under Rule 10A of Order 22 of the CPC to communicate to the court the death of respondent number 2. Full stop. Therefore, comma, while clarifying that the issue of abatement of the appeal is a collateral challenge made in this revision petition, comma, it is not for this court in exercise of revisional jurisdiction under section 115 to make any remark regarding the either of the death of respondent numbers 2, 3, and 11 in RSA 46 of 2014, as this court is not sitting over the judgment and order and consequent decree passed in RSA 46 of 2014. So therefore, comma, the only issue as to whether there can be an objection as to execution would be within the confines of section 47 of the CPC. And in this regard, the petitioner has already approached the learned executing court by filing an application under section 47 of the CPC. Next. As regards the issue raised in the application under section 47 of the CPC, comma, it is observed from the record that where is this application? Section 47 petition, where is that? My lord.
Page 70 of CRP.
Page 70.
70.
Something is wrong. This is
My lord, there is some wrong, my lord. It should be section 47, but it is application under order 47. Order 47 is review.
no. Something is wrong.
Alright.
Come to page 110. In 110, there is a reference to petition.
Yeah,
number
there is a
315 of
mistake,
24,
case was there.
which is under section 47 read with 151. Where is that?
That is plus 70.
70.
Yeah.
You're right.
Yes.
My lord, this is the petition, my lord, that has been registered as with J case. But the thing is this, my lord, Honorable High Court directed that under section 47, my lord.
However, comma, the reference made in this order regarding application under section 47 was made on the basis of submissions made by the learned counsel for the respondent. However, comma, on a specific query of the court, comma, it has been pointed out that the said application is annexure 11 to this petition, Full stop. The okay. Somehow the submissions made do not match with the document and the order dated 18/4/2024, where the learned tribal, the learned executing court has recorded the receipt of application under section 47. Full stop. The reason to come to that conclusion is that annexure 11 to to this application is a review petition which is numbered as review petition number 124 of 2025 before the court of learned Munsif number 1 at Kolkata. Full stop. From the verification and affidavit appended to the said annexure 11, the date on which verification and the affidavit was signed is 31/5/2025. However, the order of registration of an application under section 47 read with section 151 CPC is found to be recorded in the order dated 18/4/2024. Therefore, it is impossible that an application filed in 2025 would be registered and recorded in the order sheet of 18/4/2024. Therefore, what is the actual application which is filed under section 47 is not available and could not be shown by the learned counsel for the respondent. Next paragraph. Be that as it may, so it is noticed that this court, by an order dated 28/5/2025, passed in IS Civil 1686/2025, had recorded the query of the court as to why application under section 47 of the CPC was not filed before the learned executive court. Accordingly, the said liberty was granted by order dated 28/5/2025, passed by this court in IS Civil 1686/2025. The petition available at annexure 11 to this petition is review petition 124 of 2025. It's an application under order 47 rule 1 of the CPC and filed before the court of Munsif number 1 at Kolkata. Therefore, it could not be deciphered as to the purpose of filing a review petition number 124 of 2025 before the court of the learned Munsif number 1. Next, be that as it may, as per the order sheet of title execution case number 45 of 2022, from an application under section 47 read with section 151 CPC is found to be recorded against order dated 18/4/2024. The court, the learned executing court is found to be proceeding for with the proceedings of title execution 45 of 2022. Stop. during the pendency of this, of the said execution petition number 45 of the 2022, wherein the issue relating to section 47 of the CPC is also pending. The petitioner who is the judgment debtor number one in title case number 45 of 2022 has filed this application under section 115 of the CPC read with order 21 rule 29. But the prayer made in this revision petition is extracted below page 14. Next paragraph. Thus from the nature of prayer made in this revision, no order passed by the executing court is under challenge. Initially, this court is stated to have state the execution proceedings however, the respondent, who is the decree holder, is stated to have approached this court, and this court by an order. Where is that order of? Where is the order of?
That is a 32, my lord, of my,
Of the upper IA. Okay.
of my IA. IA number 55. Page 32.
State by state. I said to state, no? State by order dated 19/8/2025, passed
Authority
by
portion
this court in
34, my lord.
CRPIO 341 of 2025. The respondent number one approached this court and appeared, sorry, it is called, had appeared in the proceedings. And thereafter, this court by order dated 15/10/2025 passed in the said CRPIO 341 of 2025, vacated the stay granted on the execution of title execution case number 45 of 2022. On an application made by the petitioner, which was registered as IA Civil 3946 of 2025. This court by order dated 4/12/2025 restored the order of stay of the proceedings of title execution case number 45 of 2022. Next paragraph. As to the statement made by the learned counsel for the petitioner at the bar, we see no justification on part of the petitioner to file an application under either for review or under section 47 of the CPC in the execution proceedings, and then come before this court and get an order of stay. To stop. In this case, without assailing any order passed by the learned executing court, the petitioner Next, by applying order 41, by applying by an application under section 115 read with order 21 to 29 has repeated the prayer for stay of the proceedings, execution proceedings. To stop. The proceedings under Rule 29 of Order 21 is for stay of the execution pending suit between the decree holder and the judgment debtor. To stop. That is not the case in the present. That is not. No such suit is pending before before any court between the decree holder and the judgment debtor. To stop. Therefore, comma, the filing of this revision petition is nothing but sheer abuse of the process of court. Nothing is brought on record to show that the second appellate decree passed by this, by judgment and consequential decree passed by this court has been put to challenge. Therefore, comma, the second appellate decree, judgment and consequent decree has attained finality. Next paragraph. Therefore, comma, although a collateral challenge has been made to the decree on account of death of respondent numbers 2, 3, and 11, but that being a collateral challenge, it has already been held that it would not be maintainable in form of a revision. More so, comma, when there is nothing on record to show that the counsel holding the brief for the said respondents had discharged their onus, obligation and duty under Rule 10A of Order 22 to inform the court about the death. Next paragraph. Therefore, the only issue which can be raised before the learned executing court is issue which arises out of application under section 47 of the CPC. Next paragraph. Having observed that by miscellaneous applications and frivolous revisions, the respondent has been, the petitioner has been able to stall the execution of the decree, it would be in the fitness of the things that a polite request be made to the learned executing court, i.e. the court of Munsif number 1, Borbata. Munsif number 1, Borbata, to make an attempt to expeditiously dispose of the proceedings of title execution case number 45 of 2022, keeping in mind that a long delay in the process of execution renders the decree passed to be a paper decree only. Therefore, it's a request to the said learned court to prevent any unnecessary adjournments and to take up the matter as expeditiously as possible, subject to its convenience, taking into account the matters pending before the said learned court. So as this is only a request, it shall not be, the same should not be read as a direction of this court. Next paragraph. accordingly, upon having found no merit in this revision petition, or the same is dismissed. And in the IA, you say, in view of order passed in so and so, the application stands disposed of. Next para, both parties, as both parties are represented, both sides are directed to appear before the learned Court of Munsif number 1, Borpeta, on 1/6/2026, and the respondent by producing a certified copy of the order shall await further instructions or directions that may be passed by the said learned.
On order 47. On order 47 application,
We have not said that. We have said the execution proceedings should go up.
regarding 47 application,
47 is your choice. I asked you that 47 application, you are not showing it to us. Don't even know what is there.
so we have said answer 11,
We have spelled in our order, Mr. Mahmood. That's why we said you were reading all these laws and these provisions of law, and we told you it's not necessary for us. The things we wanted to know, we are quite aware of what you are
my,
wanting.
my last prayer. We
I'm
have
sorry,
not
good things
said-
must come to an end, Mr. Mahmood. Your submissions
No,
were
no,
very
no,
good,
only this,
but everything must stop.
or rule 5, your lordship may kindly mention. Rule 5, there is obligation also on the plaintiff.
It will not be applied. You are, Mr. Mahmood. If I say it, it will hurt you. Don't make me speak things which I don't like for a lawyer. I was there once where you are standing. I know the amount of embarrassment you will feel if I say something more. If you wanted to hear from me, you please repeat, we'll tell you what we think of it. We are restraining ourselves not to say anything. We don't want to embarrass you. But please, if you insist, we'll have to tell what we think of it. But the answer which will come will embarrass you.
Error 11 I have, that is only,
that's okay.
nothing is there,
Mr.
nothing is more there.
Mr. Mahmood, it is your choice.
Nothing is, but only 11 we have annexed that should have been.
We are giving you a fair notice that if you want, insist, we will tell you what is wrong in that order 22 rule 5. But it cause embarrassment to you. People in dreams think of very good things, correct?
No, I don't.
And when I
I
dream,
don't want to go to
when I dream, I only read the,
unnecessary dispute. I
even if-
don't want this.
even in my dream, I read CPC. Even when I dream, the best of my dreams and worst of my dreams is CPC alone. I read only that.
That we know.
Wow.
Yes, Mr. Chaudhary and Mr. Ari, I'm extremely sorry.
What problem is lost?
Just, we'll take precedence of Mr. Chaudhary and Mr. Ali. First.
Let it be next Tuesday or Thursday, my lord, I'll move convent.
Mr. Ali, what you say?
Tuesday or Thursday.
Next week, you will start fourth week.
Okay.
Date may be fixed, you know.
We'll
Next
fix it,
week,
We'll fix it. Just why we are asking your convenience.
No, my lord, I was saying that it can be taken up next week, my lord.
Any day, both of you tell us date, we'll fix it on.
Lordship, huh?
Even next
Lordship,
week, I'll do.
21st, 21st.
No, my lord, I am suggesting, do this 13, yes. 21st.
21st?
One and two.
Possibly of time. The matter could not be taken up today. As agreed to by both sides, this again on 21/5/2026. So liberty is granted to both sides to make a prayer for getting the hearing.
Right.
Lord, may I pray supplementary item 24, madam. Some urgency is there. We are facing an execution
Yes, sir, the
proceeding.
court must have to rise because at 3:30 there is
My lord,
another.
I know, my lord. Can it be taken up tomorrow, my lord? Today it is by order, my lord. Some urgency is there. Much.
We'll consider.
My lord.
Just tell the court master,
Safety of life.
consider if possible, because there is some. because,
My lord, can't short date for item number 4.
Tell the court master, just wait for some time till I rise and tell the court master. We'll try to accommodate, but we don't assure you, but we'll try to accommodate.
হয়তো কৈছে আমাৰতো কেছ কৰিব নেকি যদি 19 আৰু 21
Mongolbar. Division bench, item 1 for motion.
That matter which your lordship had earlier heard on 22nd of April. On that,
Mr. Sharma was making his submissions. He was at exhibit 4. Are you aware of, Mr. Payang, what argument Mr.
yes, ma'am.
Chakravarti has made?
The exhibit 4 is similar to total.
No. Are you aware of the context in which Mr. Chakravarti has made his submission? Because last time Mr. Sharma was there.
Yes, somehow was there, ma'am.
You're aware of the context because you must argue in the context in which he has made submissions.
My lord,
I'll tell you what he has said.
yes,
His submissions is to the effect that the proceedings had been carried out on a presumption that he is a foreigner.
yes,
In the inquiry made, there's no allegation about the entry when he's entered into India from the specified territory. And he says that if he has migrated between 166 to 25,470.
what?
25,371. It's 3, no?
Yes,
3. 25,371. Then he cannot be deported. He's referred to the birth certificate saying that he was born in 1968. And then his submission is whether the procedure was followed or not for the documents, specifically number 1, which is a public document and therefore could not have been discarded. And Mr. Sharma has come. Then voters list of the father and grandfather cannot be discarded due to discrepancy in age. His submission is that he is covered by the case of Indira Nevar, para 4, 5, and 6. And therefore it is submitted that the traveler had traveled beyond reference merely on presumption. Correct?
Before he starts, if your lordship permits, I'd like to place one decision of this honorable court.
Yes.
Now, if your lordship takes up the record, in the reference, lordship will not find as to which batch he is suspected to be a foreigner.
You told him that.
That is why, in this regard, I'm relying on a decision of this honorable court,
Sona Khan.
Sona Khan. Now, I'm relying, my lord, may I have a look at paragraph 3 and page number 5. Last paragraph, from the above, it is very clear that the referral authority has to make a reference to the tribunal as to whether a proceeding has entered Assam during 1166 to 71, 24/371 or on or after that day. So, why this has been held? Because this honorable court held that the tribunal gets his jurisdiction to give his opinion on the basis of the reference. So, the reference has to be very clear. My lord, may I come to paragraph 9 of the judgment. No, my lord, paragraph 3, last, at page 5, this is the last part. And then what is coming up from this honorable court, lordship will come at paragraph number 9 at page number 10. Having heard the learned counsel for the parties and also considering the materials available on record, we are of the view that the reference made, has the lordship got it? Reference made by the superintendent of police, Baska, cannot be said to be proper reference. Since there is already a direction of this court, the reference to be made in accordance with law, will not enter into this issue as to whether the reference could have been made at all in respect of the petitioner, so and so, so and so. However, my lord, it is very important. We are of the view that the referral authority must make a specific reference to the tribunal for his opinion as to the period during which the petitioner allegedly entered into India, which is not discernible from the material from the referral letter dated so and so. Here also, if your lordship goes to the record, lordship will not find from the reference of the SP which stream he is suspected to be a foreigner. Then at paragraph 10, we accordingly direct the superintendent to make a specific reference on the basis of the documents available with him, including the inquiry report as well as the documents submitted by the petitioner as to during which period the reference has to be made vis-a-vis the petitioner. Now here, it is important. We are of the view that the referral authority cannot make a reference merely to ascertain whether a person is a foreigner or not, without making any specific reference of a period which has a basis in terms of section 6A of the Citizenship Act 1955. It may be also noted that the tribunal also cannot give any opinion beyond the reference as already held by this court in the case of Santosh Das, thereby meaning that there has to be a specific reference as regards the period of alleged entry in case of a doubtful migrant. Then the Muslim Mandal's case was also referred. We also like to observe that the investigation or reference cannot be mechanical for the simple reason that it is the legal basis for conferring jurisdiction to the foreigners tribunal to give its opinion as to whether any person is a foreigner or not. In that context, investigation and reference assume get significance. Now, Muslim Mandal has been referred. If a lordship comes to page number 13, the paragraph starts from, therefore, in view of the above observation made by the full court of this court, we are of the view, no, page number 13, after quoting the paragraphs from Muslim Mandal, this starting from, therefore, in view of the above observation made by the full court of this court, full bench of this court, we are of the view that if no materials are available before the referral authority to doubt or question the citizenship of the concerned person, no reference can be made to the tribunal for the simple reason that it is only when citizenship of a person is doubtful or questioned by the investigating authority and the referral authority, the requirement of making a reference to the tribunal arises for his opinion. Now, if your lordship takes up the record, lordship will find, apart from one line that the petitioner's mother tongue is Nepali, nothing is there anywhere. Even the SP's reference does not specify the period of his entry. Why this honorable court, while now that, my lord, I'm also handing over the Santosh Das judgment. In Santosh Das, the reference was made suspecting the foreigner to be between the stream 1166 to 25371. But the tribunal find that he is a foreigner of post 25th March 71 stream, where this honorable court interfered and held that it is beyond his jurisdiction. Because according to this honorable court, the tribunal gets its jurisdiction from the terms of reference. So, my lord, your lordship, in view of these two decisions and Nevar's case, lordship will see that the entire proceeding is vitiated, starting from the point of reference. in this, my lord, Santosh Das case, I'll be relying on paragraph 10, 14, 15, and 16. And in the earlier judgment, that Indira Neva's judgment, if your lordship takes a paragraph 3 and 3.1, the facts of the case of Indira Neva, it is similar to the present petition. There also, there was a verification where only Nepali is the mother tongue is recorded and nothing indicated. Where from? And even there is no indication as to whether they migrated from specified territory. So, my lord, I'll reserve my right to reply on conclusion of this argument.
Is it possible, my lord, if my lord, it's a new friend, and accept that Indira Neva is a settled proposition. Indira Neva is a settled proposition. As per Indira Neva, if he has not migrated from East Pakistan, then, my lord, then in that case, my lord, this matter may be remanded, no objection on that. Because it has to be in, my lord, examined by the tribunal. If it is found to be correct as per the Indira Neva, then it can be decided there itself. So that is, I have no objection on that case, in that case, because that is settled question. Now, with regard to the reference, my learned friend has, senior friend has argued the reference is fixed. That on the basis of this reference, it cannot be met. But one thing we have to remember, this is a reference made under INDT. This is a ERO reference, which was forwarded to the SP concerned, and SP has just forwarded the matter to the foreigners tribunal for a determination. So, in the ERO's, after the ERO's direction, LBO has made an inquiry, LBO has found nothing. So, ERO has no alternative but to send the matter to the foreigners tribunal for a determination whether the person is a foreigner or Indian. That has to be determined by the tribunal. And that position is settled because this as I argued again and again, my lord, one thing, these matters, the IMDT matters, those were initiated prior to 2005. And these matters were transferred to the foreigners tribunal on the basis of the direction of the Honorable Supreme Court in the Savananda Subha. Now, these matters are sent to this particular matter is also sent to the foreigners tribunal as per direction of the Honorable Apex Court. Now, the tribunal cannot say, my lord, because, my lord, it is, my lord, clear from the Savananda Subha itself, the IMDT references are faulty. Their references are faulty. Their inquiry process is faulty. Their, my lord, tribunal, the process of inquiry is faulty. Everything is faulty there. That's why the Honorable Apex Court says, whatever it may be, this law cannot sustain. But whatever references are there, those has to be transferred to the foreigners tribunal for a determination. Now, after the direction of the Supreme Court, can we question that this reference is wrong or right? At this stage, we cannot question that these references, which were transferred by the Supreme Court to the foreigners tribunal from IMDT, are wrong. We cannot question that. If somebody wants to challenge that this transfer is wrong, despite of this irregularities in the inquiry, or whatever is there in the inquiry, if it is transferred to the foreigners tribunal, I will be prejudiced. They have to go to the Apex Court, challenging the Savananda Subha. No, all the matters, all the pending matters cannot be transferred to the foreigners tribunal if it is not inquired by one-to-one matter. So the tribunal being the matter of lowest authority cannot challenge the direction of the Supreme Court. The tribunal has to give an opinion, whatever is there in the record. So my submission is, my lord, at this stage, the tribunal cannot go whether the reference is right or wrong. Tribunal cannot make question on that, because these are transferred only on the basis of the direction of the sovereign national in 2005. That is first part. Second aspect, my lord, my learned senior friend was arguing that point that, my lord, there is no stream mentioned in the, my lord, the reference. In fact, in IMDT, my lord, there was no reference in stream at all. IMDT, there was only one stream, 1971, 471. There was no stream in IMDT. There was no stream in IMDT, my lord. So no question of reference of stream in IMDT, my lord. The simple question was, here in from the record, my lord, what I have seen, the electoral registration officer make an inquiry. Now, my lord, just I am reading the annex of the, my lord, the inquiry form, the reference. Whereas the Election Commission of India has ordered intensive revision of the electoral rule of 74 Rangapara Assembly Constitution in Assam, with reference to 1/1/2005 as qualifying date. Whereas house-to-house enumeration was done during period of 1/10/2004 to 25/11/2004, and whereas name of Srimati so-and-so, daughter of so-and-so, 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 has been ordinary resident of Rangapara town, so-and-so, so-and-so, has been enumerated to inclusion in the draft electoral rule. Whereas the electoral rule of the state constitution published on 15/6/2005, including therein name of so-and-so, and whereas I, electoral registration officer of the state assembly constituency, having doubt, this is the doubt, my lord, having doubt about the citizenship of a person, got matter verified by the on-the-spot local verification. And whereas on consideration of report of such verification, I have reasonable doubt that he or she is not a citizen of India. Now therefore the matter is forwarded to SP Shonitpur, competent authority under the IMDT Act 1983 for deciding the question whether the said Srimati so-and-so is a citizen of India or not. Whether she is a citizen of India or not, that has to be determined. So there is no fault there, madam. Now, madam, another aspect, madam, that this, madam, the LVO report does not contain totally blank, and LVO report does not provide anything to support the, madam, the inquiry. That will go against him, madam, as I have, madam, in this case, probably this honorable court, madam, has dealt with that issue. So, Kurjan Nessa, madam, 2025 to GLT 1058. 2025 to GLT 1058. 2025 to GLT 1058, madam. Sukurjan Nessa. 8. Paragraph, madam, 12 onwards. 12, it is clearly said on the basis of submission made, the very question whether the reference which is based on LGO report as forwarded by the ERO, wherein certain paragraphs, columns were left unfilled, reject the proceeding before the tribunal. This has been dealt with by madam in para 14, 15, 16, 17, and this has been clearly madam discussed, and this has been settled. In fact, what I have submitted, madam, in para 21, the reference notes were sent to the foreigners tribunal as per Sabananda Sunwal. That thing has also been settled in para 21. It's what I have argued just now. Para 20 up to 21, madam. So this has been settled that if there is nothing in the LBO report also, it does not prejudice the petitioner in any manner. Second aspect, even though suppose, my lord, the person has been this another aspect that the reference was whether he is a citizen of India or not. That must have been. So what, another aspect here, it is said by the in the report, I have seen a report by the superintendent of police, it is said, during verification, he could not produce any document as per report of the LVO. So, if now no record is submitted, no record is submitted, no document is submitted before the LVO, the LVO cannot say he came in between 66 or 71 or after 71. So the simple question was whether he is a citizen of India. Now, my lord, suppose in the reference there is no question, no stream that he is, whether he came in between 66, 71 or after 71. What prejudice will cause to the petitioner? That aspect is to be seen. My lord, he has every right to produce all documents, every evidence before the tribunal. If in the tribunal, he can produce a document of 1966 to 71 during of that period, then definitely he can establish that yes, I came between 66 to 71, so I may be treated under this category. If he cannot produce any document of 66 to 71, then he will be automatically after 71. So no prejudice will cause to him, and that position has been settled by the Honorable Court in another judgment, madam. This is in 2023, 4 GLT 1205, madam. Name versus Rukia Begum Borvia, madam. 2023, 4 GLT 12080. There the stream, my lord, whether the
Citation again,
2023, 4 GLT 1208, madam. There in para 8, 9, 10.
just a moment.
Yes. There from para 7 onwards, my lord, the detailed discussion is there. Why it cannot, it has to be accepted. Para 7, the judgment Alani Bibi is referred.
What's that one?
Yes.
Yes.
Then para 12, my lord, 13, it is clearly said, madam. What is the context of 6A and of 1955 and clause 2 of the Foreigners Tribunal Order 1964, being foreigner. The only question is foreigner, whether he is a foreigner or not, or whether he is a citizen or not. So on that aspect, it says 66, 71, 71 is tribunal not prejudiced in any manner. And my lord, being decided by the tribunal to be foreigner of post 71, if it is sent back again for re-reference, my lord, by the tribunal, it will be again, my lord, because it is already decided by the tribunal that he is a foreigner. Now it will be again, my lord, same proceeding has to be initiated, even though the reference is faulty, accepted to be faulty. If it is started again, it will have to be, my lord, started from fresh. So it will be, my lord, in fact, it is in this case, it is said it will amount to res judicata as well. So in that aspect, my lord, the tribunal's opinion, which is standing, that will survive. That will suffice, that will be available because he has got enough opportunity in the tribunal to produce his documents and produce his evidence. So, my lord, whatever inquiry, it is a preliminary inquiry before the LBO or my lord, the police. The inquiry is a preliminary inquiry. But the tribunal, in the tribunal, they got enough opportunity, being a my lord, quasi-judicial authority, to produce whatever documents they have. So the Honorable Court has said it will not prejudice in any manner. And once it is decided, in fact, it should not be sent back by the tribunal or the High Court for malad press reference.
So you're making two submissions. First, you're saying that it is that the the petitioner accepts the decision of Indra Nevar,
Yes, my lord.
then it can be sent, there's no.
It can be sent back, my lord, Indra Nevar, because there,
If it is contested on merit,
It-
then you say that it has to be, the opinion has to be upheld.
upheld. But the opinion has to be seen on its merit, my lord. Indira Navar is a technical point, my lord. It was issued that whether the, my lord, because there is a treaty, Indo-Nepal treaty, my lord. On the basis of that, any citizen of Nepal can stay in India, but no citizenship. But they cannot be deported. On that ground, my lord. Even though we declare him foreigner, he cannot be deported on the basis of Indo-Nepal treaty. So no declaration, my lord, what will remain? That is another aspect. That is which there. So now on merit, my lord, the document which is like my learned senior friend as well is the birth certificate. The leading document which is relied, my lord, is the only birth certificate. The birth certificate, exhibit A1. Exhibit 1 is the birth certificate. And this birth certificate cannot be accepted for one reason at least, my lord. My submission is that the date of birth has been shown to be 2/10/1968, my lord. 10/1968. And the birth certificate has been obtained after 19 years on 28/11/1987. Yes, ma'am. So after almost 19 years, ma'am. The belated issuance of this certificate itself says, my lord, this cannot be accepted. In fact, in the opinion, it is rightly observed in page 25, my lord, that on perusal of the birth certificate, it is crystal clear that Proceeding was born in 1968, but birth certificate registered in 1987, which is delayed in birth certificate. A delayed birth certificate cannot be issued in pursuance of the order of the first class magistrate district under section 13(3) of the Birth and Death Act 1969, but the proceeding has not proved the birth certificate nor had facilitated to exhibit the orders of the first class magistrate of district Sonitpur by calling upon the issuing authority before the witness box of the tribunal. Therefore, this birth certificate is not considered as admissible document. That is based on the judgment passed by the Sonitpur Court in 2017 4 GLT 1097. GLT 1097. The Lead Appeal 266 2016. 2017 4 GLT 1097. Their para number is not there. Just above 7 is there. 7 para from the bottom. First of all, there are grave doubts about the yes, but Rustomar. It will be around para 16, 17. Around para 6, large apartment. 6, 7 para above the matter. Yes, madam. Registration of Birth and Death Act 1969 is an act to provide for regulation of registration of birth and death and for matters connected herewith. As per Section 8, it is the duty of all persons to furnish information to the register about birth and death in family. As per Section 13(1), any birth of which information is given to the register after expiry of period specified, but within 30 days of the occurrence, shall be registered on payment of such late fee as may be prescribed. Section 2 thereof provides that any birth of death or death of which delayed information is given to the register after 30 days, but within 1 year of its occurrence shall be registered only with the written permission of the prescribed authority on payment of the prescribed fee and production of affidavit. Under subsection 3, any birth or death which has not been registered within 1 year of occurrence shall be registered only on an order made by magistrate of first class after verifying the concerned correctness of the birth and death or death and on payment of the prescribed fee. The position has been elaborately laid down in Assam Registration of Birth and Death Rules 1999, which provided information regarding birth and death shall have to be furnished within 21 days of occurrence, except in the case of Rule 9 deals with delayed registration of which in terms of the section 10. On the face of the such statutory provision and failure of the appellants to demonstrate compliance of such statutory requirement, these two documents, that is Annexure 3 and 3A, not only have to be even evidentiary significance, but considering the circumstance under which those have been brought on record, raise grave doubts about the authenticity of such certificate, more so when those were not tendered in evidence. It is quite evident that appellants have not approached the court with clean hands. So there was prior to that, what was those certificate? First of all, prior to that, in para 16 probably. First of all, there are two grave doubts about the genuineness of the authenticity of the certificate, as it is seen that certificate were issued on 9/7/2015 after passing of the order of the tribunal. In that case, on 12/2/2014, that apart, on the left, on the top corner of the certificate, there is a seal of the Office of the Joint Director of Health Services, Morigaon, while at the right side, bottom, the seal of the issuing authority was shown as registered birth and death Morigaon. But most importantly, these two certificates were issued 18 years after the birth of two children. Prior to the registration of birth and death, prior the earlier para of which we started. So my submission is, my lord, the certificate, birth certificate was issued after 19 years of the birth of the petitioner. And if it is issued after 19 years, here it is 18 years in this case, my lord, he has to bring some evidence to show that proper procedure was followed. If it is not followed during the time of, my lord, the issuance of the birth certificate, if it was not followed, if there is no evidence on record that at the time of issuance of that birth certificate, the proper procedure was followed, the certificate cannot be accepted on its face value. So, if this birth certificate is done, now what is the linked certificate of the petitioner to his projected father? Other documents, my lord, I'm not, my lord, arguing on the discrepancies here and there. Discrepancies are there in the birth years, in the, my lord, the name of father and grandfather in 1971 voter list, because 1971 voter list, the base is 1971 voter list. Base is 1971 voter list. There the grandfather name is, my lord, there is discrepancy in age as well as name of the father and grandfather. So if the birth certificate is not there, my lord, there is no other documents to link himself to his projected father or grandfather. That is the only point here, ma'am. On very. So on this basis, my submission is the tribunal has not committed wrong in any manner. So this opinion may not be disturbed. And this is this, my lord.
My lord, so far lordship will have a look at the notice issued by the tribunal, which your lordship will find at page 20. This is the Assamese version, type copy. Now, in the notice, the tribunal specifically says that I am a suspected foreigner between 1166 to 25/371. Even the reference does not say anything. IMDT, this LVO's report, everything, nothing is there. Here, I am called upon to explain why I should not be considered a foreigner of that stream. Your lordship is well aware that the stream matters. If a person is between that stream, he cannot be deported. So the tribunal, after issuing notice to give an explanation as to why I shall not be considered as a foreigner for that stream, the tribunal has given a finding beyond that period. So the tribunal could not have decided or held that I am a foreigner of a stream which is not indicated in the notice. Now, so for this judgment of this honorable court of Rustam Ali regarding the birth certificate, first of all, your lordship will appreciate one thing, that in that case, the birth certificate was produced before the High Court for the first time. It was not even produced before the tribunal. It was obtained after the tribunal has rendered its opinion. In that context, this honorable court held that first of all, you have not produced there, you have not laid any evidence, and then you have brought on this record for the first time before the writ court. In that context, this has been recorded. Now, my lordship will appreciate one thing. Even in the evidence, while the proceeding was not even cross-examined by the state on this line, that you have not, this birth certificate is not genuine, or you have not followed the process of obtaining the birth certificate. So the tribunal on its own. So in my respectful submission, this judgment relied by the state doesn't apply so far this present case is concerned. Reference of 2015 and the birth certificate is of 1987. Maybe there was a delay, but it is not the case that the birth certificate was obtained after the reference. To remotely presume that it is a fabricated or a tempered document, or it has been obtained by way of any manipulation. So, my lord, this judgment doesn't apply. If the birth certificate comes, and another aspect, my lord, the proceedee's mother was also tried under the Foreigners Act, and there is a finding that she is not a foreigner. Page number 26 of the judgment, the order of the tribunal bearing number so-and-so declaring Bosumaya Chhatri so-and-so as Indian, the proceedee has not established any link certificate to prove that he is the son of Bosumaya Chhatri. So there was earlier a proceeding against Bosumaya Chhatri, the mother of the proceedee, where the tribunal has declared Bosumaya Chhatri to be an Indian citizen. And this birth certificate not only shows he is the son of his father, he is the son of Bosumaya Chhatri also. So, my lord, my respectful submission, my lord, is a case where, and even the tribunal also in his order
opinion is dealing with the issue on presumption. I have drawn your lordship's attention to the very first paragraph. The D voter's case, he has not marked in paragraph 16 of the verification under which stream the, so it is presumed that she is a foreigner, he is a foreigner. So for my those other cases, there the persons per se, my lord, the names indicate that they, even if these persons come, they are migrated, they have migrated from the specified territory because of the names and all, my lord. But so far, Nepali people are concerned, my lord, it is highly improbable that though it is possible, but at least the verification must indicate something that there is a migration from the specified territory. But right now, my lord, my network doesn't function here, my lord. And another aspect, my lord, of course, I could not get that notification. There is also a state notification, cabinet decision taken. There is a cabinet decision taken to drop all FT matters against it. To drop all references. If, well, I could not get that notification that the state's cabinet decision to drop all.
One thing, my learned senior can has argued that point, that the at present, my lord, in Bangladesh, near about 53,000 Nepali. Yes.
So that is why, my lord, the reference report must indicate that they have migrated from Bangladesh now, specified territory. I leave it to your lordships.
With regard to that stream, that in the my lord, the notice, the stream is mentioned as 1966-71. But the tribunal decided him to be post-71. This honorable court has said, my lord, wrong mentioning of stream in the notice will not prejudice the petitioner in any manner. It is in Ananda Ghosh, my lord, 2017 2 GLT 996 itself. 2017 2 GLT 996.
Even in, my lord, Santosh Das, this aspect was dealt with, my lord. Paragraph 10 of Santosh Das.
2017 2 GLT 996. Yes.